Friends, when it comes to the question of appeals and revision, the question that could be asked in this regard is that they may go asking you with saying that discuss the procedure laid down under the Karnataka Land Revenue Act in respect of the entertaining of the matter with respect to appeals and revisions. Or in this way I can say, explain the procedure with relating to the appeals and revision provided under the Karnataka Land Revenue Act. In any of this form, they can frame you the question and they may ask you for the examination. See, once when I go with this discussion, my friends, as far as the appeals and revisions are concerned, section 49 to 59 of the Act provides for the tribunal or the various judicial bodies to entertain upon the matters relating to that of the revenue issues are concerned. And it says that when I say with that of the appeal, I speak to you with the appeal, from that of the original jurisdiction of the court, we shall see that the appeal shall be preferred to the superior body to decide upon with the matter. And the same superior body do also have a power of exercising or entertaining the revisional issues are concerned. So what are these powers? Now, how is these powers are exercised with? See, when you look upon with the adjudicating body, of course, AC, DC are considered to be as an adjudicating body. But to go literally on this, the first adjudicating body, that is, if any dispute that I have in respect of this, like say my kata number has not been properly entered into, my patta book has certain defect in it, or my RTC is not been properly made, or RTC is showing different names, for correctional of all those records or anything, I would be making my application. And in deciding upon with this, the Tahsildar is the body who would be deciding upon those areas. And against the orders, we see next comes is the AC. And above AC, there is a DC. And above DC, there is an appellate tribunal which would look out into all these matters. And against the orders of any of this, High Court and Supreme Court has the power to decide upon. But till here, we see that yesterday, even in my previous audio video discussion, I was saying you with this. But still, we see that High Court and Supreme Court, by virtue of its constitutional powers, it exercises, by virtue of appeal, it has a power to entertain the matter. But these are the bodies who are considered to be as particularly to decide upon the revenue issues are concerned, or specifically to the revenue issues are concerned. So how is this functions exercised with? See, generally we say like this, an appeal would lie, that is under section 49, it says, the first appeal would lie from every order so passed in its original jurisdiction of any revenue officers as provided under section 49. It says, I again repeat, an appeal shall lie from every such original orders passed by the revenue officers under this area. So, under below this Tahsildar, the revenue inspectors are also there, several other persons are also there, who would be surveyors are also there, all this would be doing. But when an exercise is being made, if any order is being passed, then such shall be having a right to prefer an appeal on the original adjudication made by the court. Now, who are all the persons who can do upon with this? Now, before whom you can make an appellate body? I was saying you here, AC is the first appellate authority that is recognized under the Karnataka Land Revenue Act, who will be acting as an appellate authority. That is, against the decision of the DCR, that is the Tahsildar, AC gets the power of having entertaining the matter. He has a power to entertain the matter. So I can say AC is the first appellate authority. I do also mean to say that DC is also an authority. Likewise, the tribunal is also an authority. Now, how was this can be understood under section 49? See, it says, like my friends, where such orders has been passed by the revenue officer who is subordinate to that of the assistant commissioner, any such officer who is subordinate to that of the assistant commissioner or the deputy commissioner who is also subordinate to that of the deputy commissioner, then such an order so passed by them, against such order you can have a right of preferring an appeal before the assistant commissioner of land revenue issues are concerned. I repeat this again. See, where AC is the person. When I say Tahsildar or other officers in this regard, all this are the officers are subordinate to AC and also they are subordinate to DC. When this officer, when they are subordinate to these two persons, then against the order so passed by this subordinate authorities, the appeal shall be preferred to that of the AC. That's what the Act provides under section 49. That is 1. Under the second area it says, where if an order is passed by the DC, so that is the reason why probably I'll just go back again. I was saying you that AC is the first appellate authority. You would be exercising all those functions of an appeal. You could also hear of all those functions where a reference is being made for many of these members to decide upon with. So he has a power of hearing the appeal. He also has a power of even hearing the references what is being made by any of these authorities before the AC. Likewise, when it comes to the DC, friends, it says that is against any such order so passed by the assistant commissioner, against a such order, the appeal shall be preferred by DC. That is, suppose say a reference is being made, and on that reference if the AC has decided upon the matter, then in such cases, my friends, the DC shall be a first appellate authority to decide upon the matter. And against the order, that is, if the orders that is being passed by the DC, he is in the form of virginal jurisdiction, then against such order, it could be preferred before the tribunal. That is, then the appellate tribunal becomes the first appellate authority, and the application or the petition what is being made before the appellate tribunal would be considered to be as first appeal before the tribunal. Also in such cases, where if an order is passed by the divisional commissioner, I repeat this, yesterday I was speaking to you with the hierarchy of the revenue officers are concerned. If any order is being passed by the divisional commissioner, and against such order too, the tribunal shall have a power. So in this way, my friends, 49 provides that where an appeal can be preferred. Now when it comes to the jurisdiction of DC, my friends, when we go with the jurisdiction of DC, under section 39 we see, section 71 we see, section 95 we see, where DC are being given with a virginal powers to entertain upon with or to decide upon with. Like it could be with the conversion of an agricultural land into non-agricultural land, or like an eviction of any unauthorized person who is in the occupation of that land, or maybe with respect to the realization of the land revenue, not the rent, land revenue, or where the land is required to be assigned under special purpose, it is the concerned DC has a power to assign that of the land. So in such cases, my friends, this DC shall have a virginal jurisdiction to try upon those matters. So against the order of this DC or against the order of the divisional commissioner, the first appeal is entertained by that of the appellate tribunal. So in this way, my friends, the appellate tribunal shall exercise the power. And a part of this, my friends, not only with the revenue records are concerned, it also goes further saying that is, if any order is being passed by the survey officer who is below the rank of assistant superintendent of land records or assistant superintendent of land records, or it is an assistant superintendent of resettlement, then also, my friends, we shall see. I again repeat, if an order is being passed by the survey officer who is below the rank of the assistant superintendent of land records or assistant superintendent of settlements, then against the order of this person, the appeal shall be before the DC. The appeal shall be preferred before the DC. I again insist upon with this. Now, when it is AC or with this Tahsildar who is subordinate to, if AC is not there, then appeal goes to directly to DC. Or where the assistant commissioner is there appointed with, then it is, or maybe because of the vacancy of the post of AC is there, that no post is being made up or no seat is being filled up, then you can go directly with the DC on the basis of this, that is there. But where it is specifically provided, you have to go within that particular authority. So in this way we see that the powers can be exercised. This is how we see where the jurisdiction could be taken place, or where the matter can be filed before. And in speaking upon with this, we also say, I again repeat and make you aware of this, that is where an order is being passed by the surveyor, that is by the survey officer who is below the rank of assistant superintendent. If AC, when the officer is below the rank of this AC, then it goes to AC. But in case of settlement, or in cases of the superintendent of land records are concerned, if a person is below the rank of, that is surveyor has passed the order, who has looked into the issue, who is below the rank of the assistant superintendent, then in such case, my friends, the appeal shall be preferred before the DC. Or we can also say, if the order is passed by such survey officer of land records as assistant superintendent, then also we shall see that the deputy commissioner of land records or deputy commissioner of settlement, then these persons will have a power to entertain upon the matter. In the like manner, if the order is passed by the director of survey, then that is who is settlement of land records, then against the orders of the director of land records or settlement of land records are concerned, let settlement of lands are concerned, then it is not before the DC, directly you would be going before the tribunal. So these things you have to understand clearly, my friends. Again I make it, because this is the where we always go with the confusion in it. We always confuse us with as how the hierarchy is being made. See, let me go in this. See, when it comes to AC, against the orders passed by any of the persons who are subordinate to AC and DC, both if they are subordinate, then appeal lies to AC. But where if the original jurisdiction is exercised by this AC, then it goes to DC. Where if the original jurisdiction is exercised by DC, then it goes to appellate tribunal. Where if the original jurisdiction is exercised by appellate tribunal, then first appeal goes to the High Court. But normally it is not with the first original jurisdiction this court will be having, because it is an appellate authority. It will be carried only in the form of reference or so. In this form, we can see the appeal can be preferred on that of the original jurisdiction. Apart of this, we also come across under the Land Revenue Act, that is with the settlement of land records or with the settlement of the revenue issue, settlement of land concern, that is land revenue issues are concerned. In such cases, my friends, we shall see that is where if an order is passed by the survey officer below the rank of assistant superintendent of land records, or the same survey officer, the officer who is below the rank of assistant settlement, then appeal shall be preferred before the deputy commissioner of the concerned department, that is deputy commissioner of land records or deputy commissioner of the land settlement. It should be preferred before such person. Or where if an order is passed by the surveyor of the rank of assistant superintendent himself, there I was saying below the rank of the assistant superintendent, but if the survey officer who has passed an order is of the rank of assistant superintendent himself, then also the order shall be made, appeal shall be made before the deputy commissioner of land records or before the deputy commissioner of the land settlement. So in this way we shall see the appeal is going to be preferred with. But where if the orders has been passed by the director of survey, not by the survey officer, if it is being passed by the director of this survey, that is or of land records or of the land settlement, then my friends we shall see that appeal is not before the DC, because director and DC are being put in the same cadre. So any appeal that is made by the directors of land survey, then it shall be made before the appellate tribunal. So in this way, my friends, we shall see that the orders are going to be, the petition or appeal has to be filed before the consent authority. I would like to bring one another case instance to you here is that, suppose say, that is a live example I am giving you. Suppose the trees are grown beside that of your land, and probably partially that trees on the land is grown in such a way, and the growth of such the tree is belonging to both you and the state government. That is, partly it is in your land and partly in the land of the government. That is on the edges of the government, because normally the plantations would be made. So in that case, who is having an authority? Who is a person who is to decide with? Whether AC has a power, whether DC has a power, or whether the commissioner of the land settlement has a power in this, or land records has a power in this. This question comes before us, my friends. So where the trees belonging to that of the state government are not, in such cases, the state government is an appropriate authority to decide upon with. And more particularly, this has been authorized to the surveyor. So in that case, we shall say that surveyor is the only person who has a power. Even AC/DC has no power in this. The surveyor has a power to decide upon that whether the land which is in question of dispute belongs to the state government or to that of the private individual. So we have to understand, friends, why I gave you with this is that we have to understand that who is the authority who could exercise this function, who could exercise this power of entertaining any dispute in the matter. So subject to those, we would understand how the authorities would have an appellate jurisdiction. But again, I'd like to say only after AC, that is the first appellate authority, only after AC, all these persons are considered to be as Supreme Court are also not a first appellate authority. All the other persons are said to be considered as a appellate authority, and to some extent I can say High Court is also not a first appellate authority. So in this way, that is AC, DC and appellate tribunal shall be having a power to hear the appeals that is being preferred before, and of course High Court and Supreme Court also has a power of hearing the second appeal on the subject matter. So let us get into what is the scope of this appeal. How first appeal is looked, how first appeal is entertained, how is the second appeal taken to with. Friends, here, as I was just mentioning to you with section 49, which provides for an appeal, that is from that of the any original orders or original jurisdiction, or an orders passed under the original jurisdiction of any of these persons, the appeal shall be preferred before the appellate authority, or before the, that is before AC or DC, or before the tribunal, where these bodies have a power of entertaining the matter. And normally we see that, my friends, in a case of appeal where it is being preferred, we shall normally understand like this, that is a person who is being aggrieved or a party who is being aggrieved by that of the proceedings of the lower court, that is lower body or lower authority, shall have a right of preferring an appeal before the appellate body. It is quietly understood with us, or we know with this. Maybe in your CRPC, in CPC, in all those procedural laws, you would have come across with this. So we understand this, that is, in order to prefer an appeal before the person, that is, it says that the person should have been, or the party should have been aggrieved by the orders of such orders of the lower court. But in a cases where a person may not be a party to that of the suit, but by the virtue of such an order which has been passed by the appropriate authority, whether AC or DC, if the orders are going to affect the interest of the person, if his interest is also being affected with, then such person can be also called as an aggrieved person. Say for example like this, there are hundreds of trees which is been planted on the roadside. Now surveyor has come, surveyor has brought inspection. He has carried out all those inspection and made out his report, of which one litigation has been made by a person saying that this belongs to me. The adjudication has been made in that regard. Now on the adjudication, what has happened is the court has notified, or authority has notified, saying that all those land that has been planted in the same line shall belong to the state. Now there are several other persons who are also interested in, because it was not decided on one particular tree there, it was said that all those trees which are on the line shall belong to that of the state government. Now, though the person was not a party to that of the previous claim what is being made, but by virtue of the reason that, or by the reason that his right is also going to be affected, he becomes an interested party there. Or a revisional shall also become a person who is interested. Though he might not be a party there, but because of his interest what is being affected, he shall have a right to go before, to challenge upon with the right of that order what is being passed. So even though I may not be a party to that of the order before, that is before the lower authority, but still we see that if my interest is in subject, or if my interest is being affected with, then even I shall be considered as an aggrieved party, because that of the reason that I can, being an aggrieved party, I can also avail a remedy by way of an appeal with the leave of the court. I repeat this, with the leave of the court, I shall also be having a right to prefer an appeal before the appellate court. And appeal shall always be preferred by a party, not before the wrong forum. It should be before the proper course. That's what I was explaining to you here. That is to whom, before whom you could prefer an appeal. So it should always be preferred before an appropriate authority and or appropriate forum. And if the appeal has not been preferred before an appropriate forum, then that is usually we file it in the form of memorandum of appeal before the appropriate authority, permitting upon the presence of the same before the court, that is before the appropriate authority. And if that is not being made, then it is the duty on the part of the forum, that is the appropriate authority, to return back such a memorandum of appeal to be filed before the appropriate appellate authority. An interesting case I'll come down to you with, two interesting cases. One is in case of Anandappa versus State of Karnataka. The High Court made its observation and laid down, of course, in all these areas, I would be stating to you with, or we would be understanding, or we are required to understand, not with the facts of the case. What is not required for us is not the facts, but what the observation that the court draws in almost in every area of the land issues are concerned, more particularly under the land revenue. We are required to understand what is the observation. And of course, in Anandappa versus State of Karnataka, the High Court had made its observation like this. The appellate authority, where it proceeds with the matter and dismisses an appeal so preferred, saying that it is not maintainable, the order of dismissal of appeal is preferred. What is preferred before the appellate authority is bad in the eye of law. Now look at this. See, what is the proper course? Suppose, say, an order which is required to be appealed before the AC is preferred before the DC, or order which has to be filed in the form of first appeal is filed before the tribunal, then what is the duty of this tribunal? What is the duty of this DC? He is not to just dismiss the matter. That's what the High Court made its observation. It said that it is not the duty of the High Court or the appellate authority or the DC to dismiss upon the matter, and if it does so, it is bad in the eye of law. This is what the observation the High Court has made. So what was the duty? What did the High Court call upon in that case? It said that it is the duty on the part of this appellate authority to return back the appeal, to present it before the proper forum. See, what would be the act of dismissal? Once when there is an act of dismissal, I lose my right of exercising which I had a right, procedural right, which I could exercise my right as a first appellate body. So if there is already an order of dismissal by DC and AC, If I want to prefer as a second appeal, that is not permissible because that is already been decided by DC. So these technical issues comes in while deciding upon which. So that's what the High Court has made its observation, saying that is if any order of dismissal saying that the order is that this is not maintainable, then that order of dismissal shall be bad in the eye of law. This is what we see in case of the another case I'm speaking with, in Ole Ommaru Mandala Panchayat versus Karnataka Appellate Tribunal. Ole Ommaru Mandala Panchayat. See, again here in this case, the case was something like this. Let me very briefly go with what has happened in this case. Let us not get into what the case was filed. Let me say what it has happened with the procedural error. See, the party aggrieved in, instead of approaching the assistant commissioner in the course of appeal, preferred an appeal to the deputy commissioner against the orders of the Tahsildar. So the deputy commissioner holding this appeal said that is in his observation, he said that the matter lies before the assistant commissioner and it is not before the deputy commissioner, and he further decided saying that the appellant should approach to that of the proper forum, that is he has to go before the assistant commissioner, that's what he said, it has to be filed before the proper forum, and ordered the appeal should be made before the assistant commissioner. Against the order of this DC, the appeal was being preferred before the tribunal. The tribunal, while conceding that of the appeal, whether the DC was right in dismissing the case, rejecting the application of having been heard by him, like looking upon with this, the tribunal went and observed or made his observation whether the appeal lies before the AC or DC. And there it made an observation, the tribunal made an observation saying that this was a technical default committed by the person who has proposed an appeal before the DC. It said that there was a technical defect, and it decided that, unfortunately, yes, there is a technical defect, but it went on to the merits of the case and decided. When the matter was taken again before the High Court against the order of this, that is challenging the orders of the tribunal, the High Court heard the matter very patiently, and thereafter it said that there is a serious error of law apparent on the face of the record by the tribunal itself, and said that what does the tribunal have done? So the tribunal has made a pointing saying that there is some technical error committed by the party. That is, it should have gone before the AC but has preferred before the DC. But having preferred the BC, there is a technical error what has been committed. You have to be looked into. But a part of this, what the tribunal should have done is that it should not have gone into the merits, but it has gone into the merits of the case. Where there the High Court said that there was an error apparent on the face of the decision of which the tribunal has given in this. And it said that the tribunal in disposing the matter or appeal on the merits is the matter which error is been committed, which the tribunal ought not have to be done this. Instead of dismissing the matter, it has in fact hearing the matter on merits, it dismissed the matter. And there the High Court made its observation saying this, instead of dismissing the matter, the court should have gone in the rejection of such appeal and should have asked the appeal, unlike DC, it should have asked the appellant to go prefer his appeal before the necessary forum. That is what has been provided under the statute. And he should have approached his remedy before that, because of the reason that this appellant has not exhausted his remedy before the appropriate forum. So in taking that as an observation, the tribunal said that the tribunal is not competent enough to entertain an appeal which is overriding with the provisions of the statute. So in this way, my friends, we see whenever an appeal has been preferred before the wrong forum, the duty of this forum in cases of appeal is not to just dispose of the matter, dismiss the matter, but the appropriate way or the appropriate right or the power is that to return back the said appeal to be filed before the proper forum. So this is how the appeal in case of first appeal is concerned should be entertained by the appellate authorities. This is one criteria. Coming to the next area, that is what is it in case of second appeal, section 50. How second appeal is filed and where does it goes with? As usual, see, I was speaking to you with the first appellate authority. This first appellate body is yes. Now, because when I speak with the second appellate body is about this DC appellate authority, and this person becomes the second appellate authority. That is, even Supreme Court I don't say, because it is always made on the question of law or on the certification. The appeal is going to be preferred before PC. But otherwise than this, we shall say that the appellate authority, second appellate authority would be either that of the DC or the appellate tribunal or the High Court in this regard, my friends. Now, how is this? An appeal shall lie, as a second appeal I am speaking with, the second appeal shall lie against the order of the first appeal as passed under section 49. That is, where if an order has been passed by the assistant commissioner, then it would be before the DC, deputy commissioner. Where if an order is passed by the deputy commissioner, then the second appeal lies before the tribunal. Likewise, in the same manner, if an order has been passed by the assistant superintendent for settlement or assistant superintendent for land records, then the director of survey of settlement or of land records are entitled to have a hearing on this matter. I repeat this. This is where we go confusing with. That is, if any order, I'm not speaking below the rank of, I'm not speaking with the surveyor also here. I'm speaking with the rank of assistant superintendent, where if any person, that is an assistant superintendent of settlement or the director of survey of settlement, that is the assistant superintendent of settlement or the assistant superintendent of land records, pass an order as a first appellant body, then against such order the directors of survey of, that is of, this is what we say of settlement or land records, shall be entitled to as they have been designated with, because sometimes it is DC only who takes the order of this, so he shall be having a power to entertain the matter. Where if an order is passed by the deputy commissioner of land records or deputy commissioner of land settlement, then undoubtedly it is the tribunal which shall have a power of hearing the second appellate issues are concerned. So any order, that is hearing upon any appeal by way of second appeal, my friends, we shall see this, that is such order so passed by any of this authority as a second appeal before the appellate authority shall stands to be final in nature. That is, the second appeal, unlike even in civil cases also we see the same thing, here also we see the same thing, that is orders passed by the second appellate body shall stands to be final. In a case at, that is Appachari versus Rajappa's case, Appachari versus Rajappa's case, the division bench of the Karnataka High Court held saying this, that is, it said that in view of the amendment that has been brought down to section 50, the appellate order of the land grant cases is appealable before the divisional commissioner, and there it is not before the tribunal in view of the land grants are concerned. It is, I said that is divisional commissioner, because above this divisional commissioner would be there. Divisional commissioner. So if, because DC has a power of having looking into the grants of land, is an appropriate authority. So if any authority has passed an order in this, the appeal shall be preferred before the divisional commissioner, or if DC is not there, if the powers has been given to AC, then against the orders of AC, it goes before the divisional commissioner. So in this way, my friends, appeals are looked upon with. And within what time the appeals has to be filed. See, it says that no appeal shall be entertained by any appellate authority unless where it is been filed within the limitation period. And what is the limitation period? For first appeal it is 60 days and for second appeal it is 90 days. That is from the day of the order, that is from the expiry of the day of which order of 60 days is completed with, or where if it is a 90 days which has been completed with, then in such case, my friends, we shall say appeal is going to be preferred. And that's what it says. Section 53 goes with, when you are preferring an appeal before the appellate court, the appeal shall be accompanied with the certified copy unless where such certified copy is dispensed by the appellate authority. So unless of which you have to file your appeal with along with that of the certified copy of which it is being made. Now, what are the powers of all these appellate authorities? Friends, when it comes to the powers of appellate authority, the appellate authority may, for the reason recording in writing, either annually or I can say reversing, or it can has a power, like I can say when it is going to modify or when it is going to order, the power is there on the part of this appellate authority that it can reverse the orders of the lower court, that is lower body. It can modify the orders of the lower body, confirm the orders of the lower body, remand back for deciding upon certain issues. All these are the powers. I am repeating this again. It can reverse the order what has been passed by the lower body or lower authority, can modify any of the orders that has been passed, confirm the order that is anything but has been passed, remand back for the purpose of trying out the matter on that of a particular issue, or even it can give out a directing to entertain on a particular subject. All this has been made or exercised by the appellate authority. This is the powers which they can exercise, and a part of which we also see, that is, if the appellate body is being satisfied with the effect that there is a further evidence is being required in respect of the deciding upon any matter, then they can also call for taking an additional evidences, provided it says no such additional evidences, whether orally or by documentary, shall be directed by such appellate body or by such an authority unless where the same was refused to be taken as its existence was not been made about with, which ought to have been known, which was not in existence. We all speak upon with this. That is, unless that was not been known, unless where the evidences which ought to have been known was not been known, or it was omitted out with, then it can go for its admission. Or where it also says that where the appellate authority requires any such document to be pronounced so as to enable to pronounce on the merits of the case is concerned, then only the evidences can be taken upon with. Or it says that for any other substantial causes, if the appellate authority allows such an evidence to be examined with, then such evidences can be admitted for the purpose of having looking into by way of recording the reason for such admission. Subject to this, my friends, it can take the additional evidences. I repeat this. The three situations wherein it can go. One is which ought to have been taken by the appellate authority is not being taken, or it was not been admitted, or where there is a requirement of having hearing such a document. Requirement is there that the document has to be made because it is going to be on the merits of the case, or where there is any substantial cause where the appellant has found out that it has not allowed the evidence, and that evidence is to be required to be admitted, or maybe by the appellate authority to have given a direction to hear that authority. So in such cases, it shall make a record in writing and go for the admission of those evidences. So subject to this restriction, my friends, we can see that the body, that is appellate body, has a power in respect of having hearing the application or petition, or even for taking out the evidences, my friends. So this is the powers which the appellate bodies can exercise with. Apart of this, they can also even go for the stay of execution proceedings. It says that is any revenue officer who has passed an order, any of this Tahsildar or below the rank of M, whoever who works under the Tahsildar, any revenue officers who has passed an order at any time for the time being in force or the prescribed, that is, has been as provided under the Act, if he has passed an order, and in respect of that order, if the initiation is taken, or I can say that is, steps has been taken to effect or execute that order, in the meantime, if there is an appeal is being preferred, then the party can always seek in its execution for stay of those orders as at the time of the requisition is being made, provided it says that such can only be stayed where if it is not been executed. We can also even go for status quo, that is different. But at any time the court can direct in execution, order the appellate to go with, that is to stay upon the things, that is the stay of the proceedings, and such time or for such period of time the matter, that is the execution proceedings can be stayed, or till the decision of the appeal has been made, you can stay the proceedings. So in this way, my friends, we shall see that there is also a power on the appellate body to go stay the execution proceedings. So also there is also a power on the part of this appellate body for the revision. There is power on the section 56 speaks with this. That's what I was saying to you. When it comes to the section power of revision on the appellate authorities, in fact we call it as the revisional jurisdiction of the court. The court above the assistant commissioner, or we can say that there is a rank of assistant commissioner, and in case of survey officers is concerned, the survey officer, that is superintendent of the land records or superintendent of the land settlement, is, that is assistant commissioner of the respective departments, shall be having a power to exercise the revisional powers under as provided under the Act, which we say that is on the examination of any of these bodies, the same AC shall also have a power of exercising a revisional officer. That is, where in any case, if it has appeared before the assistant commissioner that the claim or before any such officers is being required to be modified or required to be reversed, or the orders as it is being passed by the subordinate officers is required to be looked into, and as it deems fit, my friends, it shall modify or reverse the order in case of revision what has been filed. See, only thing I can say you here is this, my friends. I always keep saying this. One common understanding that we can make here, how do we distinguish where revision and where appeal is being made? See, appeals are entertained only when there is a finality in its adjudication. Maybe to the part of it. It could be to the part. But if it is completely disposing of, if there is nothing more to be decided with that part, then it is on such order, appeal shall be preferred. But when it comes to the revision is that it might have decided something, but it is not completely deciding upon with. It is just keep leaving open with. Or other way I can say, where against such order no appeal is allowed with. In such cases we go by revision. So in a common parlance understanding of us, the court which has a power of appeal to entertain the power of appeal shall equally be entitled to also entertain the revisional powers in them. Equally, not always, subject to, equally be entitled to entertain the powers of revision. That's what it says. So where the court on the adjudication made, if this court is, that is the revisional court is satisfied to modify, reverse the orders of this, then in such cases, my friends, the revision can be made. However, we say like this, the application for revision shall be exercised if the application is not being made within 4 months from the date of such order. It cannot be entertained with. So the time gap, the time frame is given is 4 months of time from the date of its adjudication. So within 4 months of time, you shall go proceed for having your adjudication. That is, you have to go for the revision. And also we see that the power of revision can only be exercised suo motu by such authority that is by suo motu by any revenue of the orders of the revenue officer, is that is in respect of any order is being passed and on which no appeal is being preferred within 3 years of time. Even in spite of 3 years of time, if no appeal is being made, then the authority shall have a power suo motu to take such revision if there is such latent defect is being made out by its order. It could be made by the parties, or it could be made on its own itself. It could be brought to knowledge on its own itself. So in that case, it can take suo motu and get into the revision of those questions. I'll be discussing to you here with the issue concerning to the revenue jurisdiction, that is from section 60 to 66. Let me just first go with this. Friends, it forms that we have just in our previous discussion or in a previous slide, we had and understood that which are all the revenue courts which comes in, how the revenue courts would exercise its jurisdiction, where an appeal can be preferred, to who all has a original jurisdiction, that is right from Tahsildar to that of the Appellate Tribunal. We have a note on that. So having understood with this, when it comes to section 61 of the Act, it says that SAFE has provided, that is subject to that of the enactment what is being provided under the Act. It says that the revenue court shall have a jurisdiction to determine or to will have an exclusive jurisdiction. I repeat this, exclusive jurisdiction to determine and decide and dispose of all those matters in respect of the revenue issues are concerned. Where it is a revenue matters are concerned, then, or if the claim is with respect to a revenue issues, then this revenue courts shall have a jurisdiction to try and dispose of those matters. And in such cases, no civil court shall have a power of exercising its jurisdiction in any of those matters which an exclusive jurisdiction is provided to that of the revenue courts. We were discussing to you about what are the powers of Tahsildar, how AC looks into, how DC looks into, what is the powers of the DCs. So in respect of any disputes with respect to the powers of what is being exercised by the Tahsildar or by the surveyor or by any other person, then it is the revenue courts shall have a jurisdiction to entertain those matters. But though one hand we say the revenue courts would exercise upon its jurisdiction exclusively the matter of revenue courts, but if the same were to be in such a case that where in trying out the private issues are concerned, if revenue matter incidentally falls in the private right, then you cannot take away the right of the jurisdiction of the civil court there. I repeat this. See, where in trying out the matter by the civil court, if that in case of that matter, if some revenue matter incidentally falls into it, then you cannot bar the jurisdiction of the civil court. That is the reason why even under the revenue code, it provides certain exception which says that though I am an exclusive power, the revenue courts has an exclusive power to decide upon with, but still we shall see that they do also have certain exception to this. So in such cases, my friends, the civil court shall exercise a jurisdiction as against the dispute that is being made. Like what are the areas? My friends, before I can go what the civil courts can do, maybe in this area when we are discussing with, we have just, that is when the question, if at all, if it is asked for your examination, you are required to just very briefly speak upon with how revenue courts exercise its jurisdiction, how the jurisdiction is conferred upon this. Maybe to some extent, what are the powers of this Tahsildar? What are the powers of this AC? Very briefly, maybe in a page or so you can go explaining with this, in a page of it. What are the powers of Tahsildar? What are the powers of AC? What are the powers of DC? And what are the powers of the Appellate Tribunal? You can explain in an extent to an extent of page. But your concern to the answer is more to that of when civil courts have a jurisdiction. Though on one hand we say it is exclusive jurisdiction is vested with that of the revenue courts, but how far it is not in case of civil courts are concerned. When civil courts gets a power. So that's what I'm speaking to you with. So 61 in fact gives a lengthy list of giving you an exception where civil courts shall have a power to be exercised with. That is in the matter incidentally where revenue issues are concerned with, which says that under section 61 class A, B, C we go on with. Under 61 class A it says that where a claim is against the government relating to the property apparently of any office of the government, then when it is relating to the property itself, I'm not speaking with the records, I'm not speaking with the entries of records, I'm not speaking with the property itself, then civil courts has a jurisdiction. Suppose say the question comes is that whether the property belongs to that of the government, whether the property is that of the government or to that of a private individual, whether the property in survey number so and so is that of the government or not. So if this question comes, it is the civil court shall have a jurisdiction to entertain the matter. And objections can also be taken before the civil courts. Like saying to this effect, the amount of any assessment on the land revenue under the Act, that is whether it is proper or not, the assessment has been properly made or not, to that extent you can take it, objections can be taken with. Or mode of levying the assessment fixed, that is in the mode in which you fix upon the levy of assessment, the principles in which the assessment is being made. For this also you can take an objection. Or for the validity of the effect of notification which that is being made in the course of survey or settlement. That is to the validity of that also you can have an objection saying that no, the civil court has no jurisdiction to entertain the matter. To this effect you have, it gives out B, provides for such an objection. So except this, the civil court shall have a jurisdiction. And C, it says that where the claim is connected with the realization of the land revenue, that is recovering of the land revenue, realization of the land revenue out in the proceedings, and if the demand has been made for recoverable of any arrears of land revenue, then the way in which you can go for recovery of land revenue is not before the revenue courts, but it is before the civil courts are concerned. Maybe if you want to go for an execution, if you go for an attachment of property, or if you want to have an arrest of a person, in all such cases you should go with the proceedings of the civil courts are concerned. This is one another. Or if the claim is for setting aside of the accounts, that is claim is for setting aside of the accounts for the irregularity or for the mistake or any other ground except that of fraud or sale, fraud in case of sale of arrears, sale or in cases of arrears, if fraud is being made out, except of this case, my friends, we shall see the civil court shall have a jurisdiction in respect of those matters. Likewise, where a claim is against the government, as like where the land, that is entry of land records, is as to the issue like whether a person is a superior holder or an inferior holder, whether a person is an occupant or a mortgager, or whether he is a landlord or a tenant, then in such cases too we see that the civil court shall have a jurisdiction. I repeat this, where a claim is made against the government, that is if the government has made certain orders saying that whether that is in the land records, I'm not speaking to title, I'm not speaking with the entries of the mistake of the administrative officers are concerned, but if the entry is in respect to the person himself, that is to himself, that is government has said that no, this is not a person, he is the person who is the owner of that property. If that is said, then revenue courts have no jurisdiction. It is civil courts have a jurisdiction, even though it could be with respect to the entry of a particular person for that matter. That is why we say that if any entry of land records has to the person, whether he is a superior holder or inferior holder, whether the person is an occupant, whether a person is a mortgagee over the property, or if he is a landlord over the property or a tenant over the property, in such cases civil courts has a jurisdiction that is against the government. Likewise, under the same E, that is class E, we see that whether the entry what has been made in the records of revenue survey is proper or not, is correct or not. To this effect too, you can have a right in before the same court. That is, in addition to that, ascertaining the occupancy right of a person or the mortgagee's right over the property. Apart of this, you can have this right. Or if there is any entry that has been omitted or amended by any officer, that can also be questioned with respect to such amendment or omission by the person before the authority. This is one another case. And it could also be in this, like class F, you see, if there is if a dispute is in respect to the distribution of land or settlement of land revenue, or even with respect to the partition of any estate in the land, then also you can go with the suit made before the civil court. Or if a claim is against the government has to, that's whether the holding of any land is wholly or partially free from the payment of land revenue. Look at this. Whether the land which is being given by the government, whether land which has been granted by the government, whether that land is entitled to the partial payment of land revenue or completely exempted from the payment of land revenue. If this is a question which has been made, you can take it before the civil court. Or if it is a case with respect to, or claim is with respect to the receipt of payment that is being made or charged on or payable to that, on or payable with that of the land revenue, if a dispute is with respect to that, civil court. Then the third one is that to set aside the cess or rate of payable, that is, if any such case is where to setting aside of such, or representing the occupation, especially, I repeat this, that is representing the occupation in respect of waste or vacant land belonging to that of the government. In these issues, if any disputes arise with, that is, whether the land belongs to the government or whether the land is a person who is having an occupancy right, who holds an occupancy right, whether the person by virtue of its usage can, that is by way of prescription, would he get a right over the property. If these issues are coming in, then we shall say the civil court shall have a jurisdiction. And under class H we see where if the claim is relating to or regarding to the boundary and fixation of boundaries under the act, there also, my friends, where that such fixation of boundaries is been set aside by the order of a competent authority or competent officer with regarding to the boundary mark or survey mark, then against the order of such an officer, you have a right to go before the civil court, exercising its power on the same. So in these cases, my friends, we shall see that the claim can be exercised by a person in respect of those matter before the civil courts as concerned. And if by virtue of section 62, we also see, it says, saving as provided under the provision of section 61, nothing shall be held or nothing shall prevent upon the civil courts from entertaining any such suits before it. It will not prevent. Section 62 is one such exception again. Especially 61 and 62 gives out an exception with this. In fact, section 61 says that is how exclusive jurisdiction subject to an exception, and section 62 also speaks out with the exception, which says that where a suit is against the government in context against the amount claimed or paid by the person, or if the amount is claimed or paid under the protest and the amount is recovered in excess to the amount of land revenue. I repeat this. See, under section 62, it says that where a suit is being made against the government, usually when we say government, we say that it is either in the form of writ petition, or we shall say that it is in the form of a petition before the land authorities, or that is the appellate authorities or revenue courts are concerned. But that is not, because even in CPC we shall see that when a suit can be instituted against the government, that is, we call it as special classes of suits, we call it as. So in that area we come across with all these things, my friends, which says this, that is, by virtue of section 62, it provides an exemption saying this, an exception saying this, providing an jurisdiction upon the civil courts to entertain upon the matter, something like where a suit is against the, that is in contest, where a person have contested himself as to the amount claimed by the revenue officer, and the same is being paid under protest. If he has simply accepted, then no. But if the same is being paid under protest, or where the amount is being recovered in excess to that of the amount what the land revenue is imposed upon will be because of long calculation or so anything that, then against such order you have a right of an suit to be filed before the civil court. Or we shall also see that if a suit is between the private parties for the purpose of establishing their private right, then that is, it could be against the government itself, although they may be affected by the entry of the same in the land records, they shall also have a right to institute a suit before the civil court. Or we shall see that if a suit is for possession of any land, maybe only or with respect to a particular survey number or with respect to such of this subdivision in that survey number, part thereof, then also in such cases we shall see that the civil courts have a jurisdiction. So in these cases, my friends, we shall see that the civil court would exercise its power in respect of any claim that is going to be made before the court. And in such cases, the revenue courts cannot bar upon the courts of civil court to entertain the matter. Subject to this, my friends, we shall say that the civil courts are barred by its jurisdiction. Which says this, that is the reason why we say in all those revenue matters are concerned, the revenue court shall have a jurisdiction to entertain the matter. All this, but subject to this exception provided under section 61 and 62. That is the reason why it says that, it says further continuing with the same provision 62, it says that no civil court shall entertain the matter in any suit or in case of any other proceedings against the state government on account of any such act or omission by the state government or by the revenue officers, unless, I repeat, unless where the plaintiff first proves that, showing that there was a previously a suit was being instituted or other proceedings was being presented, as in case of appeal, or the same was being allowed for by the law, that is by any such court in case of appeal for the time being in force. That is, within the period of limitation, it was being brought, the suit was being instituted, and as far as possible I have to establish with this, only then the civil court has jurisdiction. Otherwise, if probably after having filing a suit, or that is after having filing a petition before any revenue officer, later on if I come out challenging with this, that is not permissible. That is not permissible. That is the thing what it gives out an exception. Says that, that is, I again repeat, because you have to quote this, you cannot go without quoting this. See, one hand we say revenue courts have an exclusive jurisdiction. The consensus of me, when I write my examination, even probably for a prudent man, what you can understand is that I feel that looking down to the question paper, I should write only what are the powers of the courts. That is revenue courts and how courts can exercise its power. No. Yeah, though as a prudent man thinks that, but there is an exception. Exception plays more greater part than that of the revenue exercising of jurisdiction. So in order to emphasize the answer that revenue courts has an exclusive jurisdiction, you should bring out with this area. That is the reason why I'm repeating with this, saying that no civil court shall have a power to entertain any suit which is being made or other proceedings which is being made by the state government or against any such officer of the revenue officers of the government, unless for the act or omission passed by the state government or by the revenue officer, unless where the plaintiff proves before the court that there was a previously, that the suit was being made to the institution, proves that there was previously to the institution of the suit or other proceedings has been presented in all such appeals and allowed by law for the time being in force. If that is not there within the period of limitation, he should have done this. If that is not there, the civil courts are also having no power to entertain the jurisdiction. So the plaintiff must exhaust his right of appeal before the instituting suit, that is before instituting in against the state government. Only then he can go before the civil court, otherwise it is not. So you have to see that the suit has to be brought subject to this restriction, that is he has to prove it before that he has exhausted his remedy and he could not come across with. So only then he can go for having instituting a suit. Likewise, my friends, under section 64, we also see there is a power of the tribunal and civil court to refer the question for the decision of the jurisdiction of the respective high courts are concerned. Tribunal as well as the civil court. That is, the power of the tribunal to refer the matter, or civil court to refer the matter to the High Court, when it is by the tribunal or when it is by the civil court. So when it comes to the tribunal, my friends, that is where it finds that in any case or in any matter that has been entertained and disposed of by the civil court, and the order that is being passed against, or such proceedings are being passed against, is that is the tribunal finds to come that suo motu or on application by the party interested, if it comes to know that the statement of question is in question, that is question of law is involved in, statement of question is involved in, and the matter is required to be decided by the High Court, then in such case you have a right, that is the tribunal has a power to prefer and reference to that of the High Court. So in such case, the High Court, when a matter has been referred from the tribunal to the High Court, the High Court shall fix a date of hearing on the question of which it has been referred with, cause a notice to that of the opposite party in respect of such matter, and the matter can be heard and considered as the case required with, and send a copy of the decision of the same to the tribunal on which the reference is being made. And mind this, my friends, even the decision of the High Court is subject of appeal, and that could be presented before the Supreme Court. So this is how we get Supreme Court's power in exercising the jurisdiction. That is, on a reference so made, if the High Court decides and sends the matter against the decision of the High Court, you have a power to go before the Supreme Court. Or even where if the matter is been remanded without to dispose comfortably on the decision, you have a right against such remandal also. So in this way, we shall see that High Court has a power. So High Court, in considering upon with this, it can go in consideration whether the act is being imperfectly framed, or whether the proceedings are being imperfectly formed out with. High Court, into this effect, can also go in remanding back with the suitable amendments that has to be made. Cost of such references shall also be dealt in each High Court and direct for the same. This is how the High Court exercises its power in cases of reference. And when it comes to the power of the civil court to make a reference as to the jurisdiction of the High Court, section 65 speaks with this. It says, after having instituted any suit or appeal which has been presented before the civil court, where if the judge doubt himself, saying that is been precluded or been restricted by under any act for the time being in force, that to entertain upon the matter, that he himself doubts with whether he has a power to entertain, whether he has a jurisdiction to entertain the matter, whether he has a right to dispose upon the suit or appeal, then he can also go proceed for making a reference to that of the High Court. Even there, the same proceedings goes with. The High Court may order on the making of such reference made by the court, either to proceed with the case or return the plaint to the appropriate court, if that is so. And in such case, the order of the High Court in such reference shall be subject to the question of appeal there, and the same can also be challenged before the Supreme Court as to its finality. However, one I would like to say here is this, my friends. When the references is being made to the High Court, that is both under section 64 and 65, the High Court High Court hearing upon this matter shall be heard only by the bench, that is consisting of 2 judges. No single judge can entertain upon the matter, because probably in an appeal or in the cases of civil cases are concerned, in most particularly in tribunal, we see 2 or more judges would be sitting. So when a reference is being made, it should be heard by the bench of 2 only. So in such way, my friends, we shall see that the powers are being exercised by the revenue courts. That is the reason why we say that revenue courts shall have an exclusive jurisdiction to entertain the matter, subject to the exception what I have just spoken to you under this area, my friends. That is where it says that is where the court is being satisfied both under section 61 and 62. Subject to those exceptions, these revenue courts shall have a complete jurisdiction in respect of the revenue matters alone. But where a private right private right comes in, the revenue courts are barred with the jurisdiction. Maybe with respect to the title, with respect to the interest, or with respect to the possession of property. If any rights of such kind comes in, then revenue courts are being barred with the jurisdiction on those areas. But otherwise, we see revenue courts shall have an exclusive jurisdiction to try and dispose upon the matter. So this is what you are required to write when the question is asked. Speaking upon that, revenue courts shall have an exclusive jurisdiction to try and hear the matter of revenue issues.